Hello, good morning or good afternoon. It's Thursday. It's 12 o'clock, and we are very excited to share with you all today. Well, first of all, is Elizabeth Ricci's wisdom and experience. So thank you, Elizabeth, for joining us today. And let's give attendees maybe a minute so they can join our webinar today. And yes. A lot of excitement out there since right the bulletin came out last week, right? Are you getting a lot of calls and emails, Elizabeth, from?
Starting Friday, I was getting so many emails. I had to change my auto reply to say, if you're a current client or interested in an NIW and have questions about the bulletin, and then I give them some bullet points that hopefully answer their questions right from the get-go, because it was just too much. I have other things to do than be answering these questions. So this is really helpful, Marco. Thanks for doing it, because I'm going to be sharing it with people who are asking and need more than an auto reply to answer their questions.
Perfect, perfect. Thank you. Okay, so my name is Marco Scanu. I am the founder and, as I like to say, orchestra conductor of Visa Business Plans. And yes, I am also an immigrant. I will share my immigration story in a couple of minutes. But first, I want to welcome again Elizabeth Ricci, managing partner at Rambana and Ricci. And I never asked you where in Italy is that Ricci from? Do you know?
Well, it's a very common name in Italy. It means curly hair.
Uh-huh.
And so my family was from Naples.
Oh, Napoli. Nice. So, thank you. So, we have today a very interesting webinar, NIW's current insider NIW strategies you cannot afford to ignore. But put it simply, what's next? What should I do? Right. So, again, thank you for joining us today, Elizabeth, and I want to share with you a little bit about my background. As I said before, I am an immigrant. I was born in Venezuela, like many Venezuelans have half Venezuelan and half something else. In my case, half Italian. And I've been an entrepreneur for more than 35 years. And so I know what it means to launch, grow, and scale businesses. And I migrated to the United States in 2009 under an O1 visa in entrepreneurship. And after that, I transitioned into an EB1A, also in entrepreneurship. To want to be very honest with you all I cared about, like many of your clients, is I want my green card. So anyway, I brought that experience as an entrepreneur, and I spent most of my years as an entrepreneur in the food business. So I was in the restaurant business, gelato business, and food manufacturing. So I always like to share with our clients that the biggest takeaway from my years in food manufacturing was quality assurance with food products. You have to do it right the first time. Otherwise, you either throw away your product or you irresponsibly sell your product and run the risk of, killing people and going to jail. So I bring that obsession with detail and quality to everything we do. And in 2009, I founded Visa Business Plans. And since then, we've done around 9,000 immigration business plans. But more importantly, we have learned from a ton of immigration attorneys nationwide. And fun fact, Elizabeth, we worked together for many years on many cases, but we only met in person back in 2023, right? So that was very
Yep.
interesting. So we're here to basically help immigration lawyers win cases and to help our clients get their visas approved. That is the bottom line. So, Elizabeth, tell us more about you and your background.
Thank you. Thank you for inviting me. So I've been practicing immigration for about 25 years. I'm active in AILA, and that's where I met you, Marco, at that AILA conference in DC a few years ago. I think you recognize me from LinkedIn.
Oh, yes.
So I practice mostly business immigration, mostly EB1A and National Interest Waiver. I, of course, do naturalization and family-based adjustments, stuff like that. My husband's my law partner. We met in law school. He does deportation defense. Um, And I do a lot of work pro bono for veterans. In fact, if you're in South Florida, you'll see me on ABC tomorrow talking about a veteran case. I've taught at Barry University in South Florida. I've taught at FSU, the College of Law up here. I like to write about immigration, and I'm happy to share my thoughts. I know this is a very important topic to people who got I-140 spending, who are thinking about filing, for attorneys who are getting a ton of questions. So this is a big shift, and I'm happy to share some insights with you all.
Perfect. Thank you. And here's the agenda for today. So first topic is going to be filing your green card, the I-140. 485. Then there's a typo there, so I apologize. The National Interest Waiver is current again. What should I do now, right? Then we're going to be talking about the EB1A versus the National Interest Waiver, and then the FAQs, or we're going to be open to questions. So first, very important disclaimer, as I like to always describe how we work with immigration lawyers. You see here a medical doctor and a nurse, and the way that we collaborate in visa business plans with immigration lawyers is that the immigration lawyers that tell clients they're the medical doctor, right? They're the ones qualified to diagnose your case and define or decide the treatment for your case or the case of strategy. We are like the very, very experienced nurse who has seen thousands of cases. And the way we like to work is based on so many cases that we see in adjudication trends when we're working on a plan, and we see something that based on recent cases that we have worked on, could be an issue. We're here to communicate with a lawyer handling the case, just say, hey, heads up, we're seeing this trend, but it's your decision. You're the lawyer, we're not, and we never provide any type of advice or legal advice or anything that sounds like legal advice. So you want to talk now about your first topic. Go ahead, Elizabeth.
Yeah, thank you. Before I do, I want to mention I really love that graphic. So many people don't go to the doctor for their medical
yes.
right? They go to their next door neighbor, their cousin who had the same condition. AI, this is not the place to do that. This is the most important thing in your life if you're the applicant. And just like you wouldn't do that if you had a medical condition, go to a neighbor or somebody who had a similar condition, you don't do it in a legal context either. So there's a lot of considerations to be had with the fact that the bulletin moved to current last week. I think the best advice I can give you today is that the decision whether to file for adjustment is individual, and it should be made on a case-by-case basis based on your particular facts and circumstances. First big question, most of my clients are from Nigeria, which is subject to the presidential pause on immigration benefits. The question is, are you subject to the proclamation or not? If you're subject to the proclamation, then you have to consider, do you already have your I-140 approved and you were just waiting on the date, or is your I-140 still pending? You can request an exemption from the proclamation. The language that I'm using for people who already have their I-140 approved is the granting of the holding at this stage after USCIS has already found that my work serves the national interest would be inconsistent with that prior adjudication and would undermine the significant public interest already identified by USCIS. And you can send that request to the Office of Policy and Strategy. My suggestion is also to add it to unsolicited evidence on your USCIS account if you have one. And then, of course, the office that either is already handling your I-45 that's pending, or if you're going to file one now because of the current bulletin, to also send such an exemption request to that address. You have to keep in mind that with this new incredible multi-billion-dollar budget increase, immigration is also going back and revoking approvals of I-140s that were already approved. So even if you have an approval, it doesn't mean it's going to stick. They are revoking some approvals, which is a concern and something to be aware of. Keep in mind, too, that your current status is something that needs to be taken into consideration. I had someone reach out to me this morning. His I-140 is pending, and his employer just told him that they are not going to sign off on the STEM extension. So you have to think, do you have time to make a decision, or is your current immigration status dictating the necessity of filing the 485? That's different case by case. Next month, mid-March, we'll know what the April bulletin is going to look like. Maybe it would be a good idea to wait and see what's the April bulletin look like. I use this analogy, right? You don't go to a restaurant on opening night. It's crazy. The food's not necessarily ready. It's just like the registration for the H-1B lottery. I don't do it in the first few hours. On March 4th at noon, you're not going to see me doing registrations because everybody's going to jump on. It's going to crash, and it's not going to be good. Wait a little bit. I always love the phrase "cool heads prevail." So have a cool head when you're thinking about these considerations. Consider, too, immigration is going to have an influx, especially of premium processed I-140s. They don't have the time, and they don't have really, unfortunately, the interest to adjudicate well in a quality way. They have up to 90 minutes to work on a case. So you need to think about that as well. Make that individualized choice based on your facts and your circumstances, what works for you. And your budget too, right? The premium processing fee is going to go up on March 1st. Think about whether you can afford that, whether it makes sense to file premium processing, especially that you don't have to have the approval for the I-140 to file the 485. You can have them simultaneously. You don't need the approval first. And that is a question that I've been getting a lot lately. Do I need to have the approval first? No, you don't. You can have the case pending. But obviously, if it's the 140 is denied, that means that the 485 is going to be denied. The 485 is necessarily connected to whether the I-140 is approved. Now, the I-485 will give you status and the ability to file that work authorization. But if you're subject to the proclamation, then they're not going to adjudicate it. And you may have another way to maintain status. So those are all things I think that need to really be considered and weighed with great consideration.
Perfect. Thank you. Thank you. So a lot of things to take into account when making that decision. So let's see. Now we have second topic. So go ahead, Elizabeth.
Sure. So this is not a situation when you are filing, whether you're premium or not, but especially if you're premium. When you file, you have to keep in mind that immigration is getting sued a lot lately. And we saw that last month with the Mukherjee case for EB1A. They're making things up. They're making up regulations. They're making up requirements. And you have to hold them accountable. So one way to do that is to be really precise in your arguments that are consistent with the policy manual. And, when I was in law school, our professors always said, don't throw everything against the wall and see what sticks. That's not the best approach. And that also is true here. So what I mean by that is, I had an example of somebody who hired me recently to take over her request for evidence on a national interest waiver. And I said, okay, send me what you sent to immigration. Let me see it. Her cover letter was 671 pages. They don't have the time. They don't have the interest. And that puts the burden on them. They're not allowed to take time away, by the way, in the premium context from a non-premium case to work on a premium case. As antithetical as that is to the idea of premium processing, they're not allowed to do that. So they're going to put the burden back on you. Instead of reading 671 pages, just the letter, by the way, it's your responsibility to make it concise, to make it easy, to make it quick for them to understand, approve, and move on. So I love that Mark Twain quote, I didn't have time to write a short letter, so I wrote a long one instead. It's easy to throw the spaghetti against the wall and see what sticks. Don't do that. Don't fall for that temptation, because that's going to turn around and bite you. I strongly don't suggest doing that. So these are the kinds of things I want you to think about as far as whether to file premium, whether to file for the adjustment. But I want you to keep in mind too about the policy manual. That is their own rules, and you should use their rules back at them to explain why you're eligible, and also let them know that you're keeping them in check and that they can't be making things up. So I can go into some more detail on the policy manual now if you want, Marco, regarding merit and national importance.
Please do.
Yeah, okay. So there are three prongs, right, on a national interest waiver. You've got substantial merit and national importance, well-positioned, and why the labor certification should be waived. But that first prong is really two prongs. Substantial merit and national interest are really two different things.
Mm-hmm.
The substantial merit is the intrinsic value of the endeavor. And I know you're going to talk about that some more, but it asks, is this work genuinely worthwhile? And the manual, the policy manual, which you can find at uscis.gov in the search bar, just look up policy manual. It casts a really wide net. Merit can be demonstrated in business, entrepreneurship, science, technology, culture, health, or education. And the manual specifically states that merit, quote, may be established without immediate or quantifiable economic impact, and that endeavors in pure research or the furtherance of human knowledge can qualify even if they're unlikely to translate into direct economic benefits. But you might see requests for evidence asking for economic benefits. You don't have to show that. And that's where you use the policy manual when you show them, well, that's not really what your own rules say, immigration. It's the lower and more forgiving of the two parts of that first prong. National importance, which a lot of people confuse, They want to argue why their work is nationally important. That's really the same thing as why it's meritorious. The question is how the individual applicant can have a national impact.
Hmm.
And that's very different from the value or the merit of that work. So national importance, that's my timer, looks at the scope and breadth of the endeavor's prospective impact, the impact in the future, and it asks, does this work matter beyond the individual employer or in a narrow context? If immigration thinks your impact is employer specific, even if it's Amazon, a lot of my clients work for Amazon, that does not mean that it's not nationally important. Amazon has a huge footprint, but you have to make the argument about why your endeavor is beyond an employer. And that's
Hmm.
where a lot of the petitions, I think, fall short. And the manual devotes a lot more attention to it with some explicit warnings and negative examples. I'm going to just read this to you. National importance is where the argument must be built with specificity, concrete evidence, and a clear narrative connecting the individual's particular work to impacts that transcend their employment relationship. Generic field importance arguments will not carry it. So in those 671 pages that the person hired me to fix, it was general. Those were really 671 wasted pages. They need specifics and in a lot less pages than 671, by the way.
Hmm. Well, interesting. So it's I love it, and I we actually use and read and discuss the policy manual with immigration lawyers because at the end of the day, a plan has to, a business plan or professional plan is evidence that you lawyers use to, help your clients' case. So it's important to understand what is it that immigration officers are looking for.
Right.
So
It's their map. Give them
exactly,
their map back to them.
exactly. So you were already talking about this, right? That substantial merit and national importance, right? So
Yeah.
we'd
And the
like to
manual, I can't stress it enough. Use that manual.
exactly, exactly. Yes, and again, I'm not, I mean, an immigration lawyer, but I like to, lawyers that we have worked with for years like to call me an immigration law nerd, right? Because it's key to understand, right? That map or that guide that officers use, the policy manual. But not only that, I've heard lawyers say, and want to really build a strong case so that if I'm going to litigate, I'm not speaking specifically about the National Interest Waiver. If I'm going for litigation or whatever, I can show that I build a strong case, right? So that's something that I find really interesting. So anyway, let's thank you, Elizabeth. So I want to share our perspective on the things that we have learned over the years and on the National Interest Waiver space. And a few months back, we analyzed around 800 RFEs and denials. We are contacted quite often by either immigration lawyers or applicants or people who file their own petitions, and they send us the RFEs and denial letters and what are your thoughts. So we keep track of the things that we're seeing, the trends, right? And basically they have not changed in the sense that the number one thing that we see out there, the USA is challenging, is the national importance. So basically, 7 out of 10 RFPs or denials, right, challenged the national importance component, right? Number two, a vague proposed endeavor, and I'm going to be talking about what we have seen is a vague proposed endeavor, right? Not detailed enough. So 1 out of 2 RFPs and denials that we've analyzed challenged the proposed endeavor, being vague. And third, the well-positioned, and we've seen over the last few months, the well-positioned requirement being challenged more and more, right? And in those RFEs and denials. So, with these numbers in mind, what I'd like to talk about is something that when I started these business plans, remember, I've been an entrepreneur for 35 years. I didn't know anything about immigration, but then when I was as an entrepreneur, of course, I worked with lawyers like the labor attorney and the corporate lawyer. And I was always for years very curious about, okay, if we're in front of a judge, how do they make a decision? Because, the law can say whatever, but in my view, what really counts is the interpretation of the law. How do they make this decision? So when I launched this business plan, I quickly realized, look, you could have the best lawyer in the world, but it's about the immigration officer making the decision. So I really got obsessed with understanding who these officers are, what their profile is, right? And basically it's training that I brought, 35 years as an entrepreneur. It's all about understanding how do my clients think? How do they make decisions? That's key for success. In business, same thing in immigration. So I've been studying and trying to understand how these officers think and what their background is. And earlier this week, it was really interesting with, as Elizabeth and I were talking about this webinar. So look, nowadays, the USCIS, and this is a screenshot from yesterday, right? They're offering a 50,000, which is not shown here, $50,000 bonus. No college degree required, right? So you have this person, nothing against someone who has no college degree, but many national interest waiver cases are super complex, super technical, right? And then you're dealing with the law. So I've always wondered, I don't know how long the USCIS trains an immigration officer, but I see a disconnect between how many years, Elizabeth, a lawyer, right? So you go to college, you get a degree, and then you get your law degree. How many years are we talking about, right?
So
And then,
7 years of training
mhm.
plus a bar exam, and they don't have to do that. They can have a GED or a high school diploma.
Exactly. So you have, wow, that's mind blowing. But at the end of the day, we cannot control that. But then we have to be smart about how do we build an effective case, taking into account the fact that, as you were saying, 90 minutes. So I am a numbers guy. I run some numbers. So on average, right, at a normal reading pace, a person can read about, in that time, 18,000, 22,000 words. So in 90 minutes, they can read 45 pages. Let's say that it's double that, 180 minutes, that's 3 hours, 90 pages, right? So back to what you said before, which is, right? I didn't have time to write a short letter, so I wrote a long one instead. So it's about being concise, persuasive, straight to the point, and presenting or showing information that is relevant, right? It's all about understanding and knowing your audience, right? So I wanted to share that because that's key. That for me is the most important thing, at least from my perspective and as a businessman. So I wanted to briefly talk about the proposal endeavor. I see and we see a lot of a lot of people making the mistake of confusing an occupation with a proposed endeavor. So since we're dealing here with language and the meaning of words, what does the dictionary say about what an occupation is? That is a profession, right? That is a principal activity. Whereas if you look at the words proposed endeavor, right? That's an intent to do something with your occupation, right? And an endeavor is an activity directed towards a goal. So in other words, how the applicant will use their occupation to achieve something. So I come across a lot of RFEs sending us in. I'm not a lawyer, but when I read all my proposed endeavor, I'm going to be an engineer. That's an occupation. That for me, and I've seen it, and we keep track of that data. That's you're asking for an RFE. I'm going to be an IT technician. That is an occupation. That is not a proposed endeavor. Tell me what exactly you're going to be doing with that occupation. So 50% of cases that we see a vague proposed endeavor is, this is a perfect example. I'm going to be an engineer. So when we work with cases like that, instead of oil engineer, maybe I'm going to be an oil and gas process optimization consultant. That's a very specific endeavor. I'm going to be a consultant, or I'm going to be a manager, whatever it is. Same with data scientist. Instead of being a scientist, I'm going to develop web-based solutions to help small and medium-sized businesses manage financial risks. See, two different things, right? The proposed endeavor is a very specific action that I'm going to take with a very precise goal in mind. Same with architect, right? That's an occupation. A good proposed endeavor could be, I'm going to be a consultant in energy saving for building solutions, right? So again, occupation versus proposed endeavor. Proposed endeavor has an action verb. I'm going to be doing this towards this goal.
Marco, before you go on to that next slide, I want to mention a nugget that I've seen in a lot of requests for evidence lately with regard to this, and that is that officers are asking for proof that the profession is, quote, an integral part of the endeavor. So even though that's not in the policy manual, I'm mentioning, use the policy manual and give them back their same language. When you get support letters, they should say that the profession is an integral part of the endeavor. So the officer can check that off the list of things that they're looking for as a reason to deny. Integral part is very important.
Wow, interesting. Thank you. Thank you. Perfect. So another in our analysis, again, 7 out of 10 RFEs and denials that we analyzed, they challenge the national importance. But the main, and this is a screenshot of an RFE where, I see this a lot. We see this quite often, which is, speak with clients where we read what they wrote and they say, oh, but I'm going to be doing, again, oil engineer and, oil and gas is very important for the Trump administration. Okay, yes, the fact that you're going to be active in an area that is strategic to the United States doesn't mean that it has national importance. If that argument was valid, then I could say I'm selling, I don't know, chairs to oil companies. And since I'm selling chairs to oil companies, that has national importance because, without chairs, staff members cannot sit at their desks. So you say it's we see a lot of that. So it's and the RFEs that we see often, they say, hey, it's not the importance of the field, right? Show me how your specific endeavor, show me a correlation, a cause and effect relationship. This is exactly what I'm going to be doing. This is exactly how my endeavor is going to impact, right? This is how it's going to be important for the United States. This is why I like to call this visa the superhero visa, right? Because you have to show that it's like Hollywood. You have to, we have to portray you as a superhero, right? Saving the US from doom or whatever. So again, the importance of the field is not, again, from our perspective, what they're looking for, but the specific importance of the specific endeavor. So what we can do to help lawyers is, we always take the time. In fact, about 90% of the time we spend writing business plans or professional plans is analyzing the case and coordinating with the lawyer and trying to find the right angle so that we can show national importance. So our work is more on the strategic side. And yes, we write the plan, but the plan is the last step in the whole process. Another thing I wanted to share, going back to AI, and of course, quite often clients say, okay, why should I hire you, or why should I hire my lawyer? Because I spoke with my friend and AI can do everything. Well, AI is good for a lot of things, except that it produces generic language, right? That's number one, and a generic petition and generic plan will not cut it. Second, and this is key, as I tell clients, how does AI work? It goes online and it's super efficient reading and gathering information, but guess what? Current adjudication standards are changed by the week. That is never updated on the internet, right? I mean, it really is. There is not sufficient information out there so that AI can really get the nuances of the new adjudication trends and the new patterns. Like what you said before, show me the connection between your profession and the proposed endeavor. They have to be like husband and wife, right? So that's key. But more important than that, and I always tell clients, especially those that say, oh, but I can do it myself. The lawyer's just going to be filling out forms and so on. I say, look, AI will never replace judgment. I mean, that's extremely important, right? And last but not least, and this is an interesting trend that I've been seeing and we've been seeing, and I attended the ALA Latin American chapter conference in Barbados. One panel was all about how lawyers are starting to see cases denied with language or challenged, saying, hey, those letters, those are AI, right? So my understanding is that officers are now being trained on how to detect boilerplate language. So it's super important. This is what we're seeing across the board, and as we speak and learn from lawyers, I wanted to share this with the audience today. Okay.
Before you go, Marco, on that same point, I make the joke. They use boilerplate language all the time. It's only okay when they do it, but not when somebody else does it. But back to the AI real quick.
Hmm.
When the visa bulletin changed last week, I put in, after knowing we were going to have this webinar today, I put in two different AI platforms. I'm Nigerian. I have an I-140 pending. Should I file for adjustment? And I wanted to see what it was going to say. And both platforms came back with basically, yes, you should. There was no consideration for the proclamation. And I made sure to say Nigerian because that Nigeria is subject to the proclamation. There was no mention about any of these factors that we talked about. AI can't take those things into consideration.
Exactly. Great point. Great point. Perfect. So topic number 3. Go ahead, Elizabeth.
Yeah. So most of my practice is EB1A or National Interest Waiver, and they're not interchangeable. They're totally different. So many people want to use the same evidence they use for one for the other. It's a different legal standard. And I think the most illuminating way to understand the distinction between EB1 and NIW first is one's more subjective and one's more objective. EB1 is a classification you earn through past achievement, while the
Hmm.
National Interest Waiver is a benefit you granted through a persuasive argument about the future. EB1 points to things like a Nobel Prize, a high H index, research or employment at an R1 or an R2 or a highly ranked US university and says, look what I've done. Look at how great all of these things are that I've already done. It's not a 3 out of 10. That's the 3 out of 10 regulatory criteria. That's not part of the National Interest Waiver, where the petition points to a business plan or a specific endeavor plan, interest in government agency requests, investor commitments, market analysis, and says, look what I will do in the future and why the country needs me to do it without having to wait for a labor certification. So in practical, it has practical consequences. EB1, a weak argument can be rescued with a lot of evidence. A truly extraordinary body of work can speak for itself. In the national interest waiver context, even a strong evidence can fail if the narrative connecting it to the national importance is not carefully constructed, because there's no checklist of regulatory criteria, the 3 out of 10 that there are for EB1, that once satisfied compels an approval. The officer retains broad discretion to weigh competing considerations and reach a judgment call. And I don't know about you, but I do not want someone who does not have a college degree deciding my fate and making a judgment call in less than 90 minutes. And that's why, for the right client, an EB1, which is more objective, may be better than even a well-crafted national interest waiver petition, which can succeed for someone who would not clear the EB1A bar, and why for a different client, a towering amount of credentials in EB1A can actually be the cleaner and more predictable path. So you have to understand which standard serves who in a better way, giving all of these considerations and strategic judgments, that they are different and they need to be considered separately.
Exactly. Okay, so you already spoke about this, right? Your second slide. Okay, wonderful. Wonderful. And what trends are you seeing out there in, let's say, EB1A versus National Interest Waiver RFEs?
Well, for EB1A, traditionally, before January of last year, if you met 3 out of the 10 criteria, it was understood that you met a claim. And you didn't have to prove benefit separately. And then I started getting RFEs about proving benefit independently. I had somebody with a patent recently, which usually is really great for an EB1, and immigration came back and said, well, you have to prove the probative value of the patent. No, I don't. I have to show that it could be commercially successful or there's interest in it, but I don't have to prove probative value. So a lot of kind of invented criteria. And then, of course, immigration got sued, and that was that EB1 case, Mukherjee, and they lost. And so now, although Mukherjee applies specifically to the Mukherjee case, there are ramifications for other applicants. Specifically, that sustained claim is a made-up idea by immigration. It's not the regulations, and you can't require sustained claim, especially for people who are early career. They haven't sustained it yet, but they still are extraordinary. So a benefit and sustained claim I've seen change, which means now that because they're being sued, you need to give strong evidence of those 3 out of 10 criteria. You still have to show top of your field, and you still have to show you're going to continue in your field. Immigration all of a sudden is asking now for proof of job offer. The regulations specifically say no job offer is required. I print out the regulations and I show that. But rather than duke it out with them in an RFE, almost all of my clients are employed anyway. I do give them proof of a job. For
Okay.
national interest waiver, I am seeing much more subjective interpretation, especially with regard to well-positioned. What I think is well-positioned, what you think, what they think may be completely different. So I tell
Mhm.
people overly document that one, but they are going after that national importance factor fiercely, because if they can
Yes.
show that you don't meet that, they don't even have to bother adjudicating the rest of the case. And that really needs to be addressed in a solid, zipped up way right from the beginning.
Exactly. So the trends that you see in EB1A and national interest waiver RFEs is impacting how you put together your packages. Well,
Oh yeah.
what is the main change that you have incorporated into your findings in response to these new trends?
Well, more specific evidence, making the connection stronger. It used to be where if you proved substantial merit, by analogy, you were showing that the labor certification should be waived. You can't, I mean, logic dictates that that is true, but
Hmm.
you have to now give re actual documentary evidence of one of the five reasons. It's impractical to secure a labor certification, get a letter from the employer saying we don't sponsor for whatever reason, we don't have the budget, it's not,
Hmm.
we're nonprofits against our bylaws, whatever. You show, and with letters and other documentation, the benefit is sufficiently urgent to warrant foregoing the labor certification. Use that language. Have your supporters say that phrase. Have your supporters say the U.S. would benefit from you regardless of the availability of U.S. workers. And here's where you come in. As you know, Mark, I recommend you to a lot of my clients because they have trouble with either of these last two. That is that you could create jobs. You know, a lot of my scientist clients can't show that they can create jobs directly, but their work might indirectly create jobs.
Hmm.
So that is an argument worth making. And then lastly, that they're not going to be working in an area that negatively impacts U.S. workers if they're self-employed. Well, you can say that. That's conclusory. We have to prove that you're not working in an area that's going to negatively impact U.S. workers and or that you're going to be self-employed. So those used to be self-proving. When you prove substantial merit, no more. You have to prove those individually. Just one of those five, but obviously the more that you meet, the better.
Perfect. Great example of how adjudication trends basically are a moving targets. So thank you, Elizabeth. I wanted to briefly talk about how we support our clients, immigration lawyers, with field of endeavor plan for EB1As, right? Remember, I came in at an EB1A, so I'm O1 EB1A, and I went through the process myself, went through two RFEs, so that was interesting, but I learned a lot. I still learn, every single day with our clients, and so when we do the field of endeavor plan is always remembering coordination with the immigration lawyer. We clearly define the field, right? We also want to highlight the past extraordinary achievements from the applicants, and we want to describe the future work in the US, and lastly how the US will benefit from the beneficiary's presence. And we don't get into the national interest, right? But more of an overview, again, depending on the immigration lawyer handling the case. We always ask the lawyer, is there anything in particular that you want to see or you don't want to see, any type of language? Because each case is different, and we don't use templates. We don't use copy and paste. That's a no-no. So for EB1As, we can help with the field of endeavor plans. We've seen that mainly in smaller law offices that maybe don't have the bandwidth to do everything in-house. They seek our help with certain cases, or to strengthen the case, again, on a case by case basis. When it comes to national interest waivers, it's interesting. Often I hear the clients ask, "Oh, is it better to have a business plan or is it better to have a professional plan?" And the answer that you lawyers are familiar with is, it depends. Right? So it depends, but over the years, what we have seen is a trend where, in most cases, we will, the lawyer handling the case would request a business plan for an entrepreneur or business owner, right? And instead for a professional, maybe working for an employer. We've done, by the way, also, as you mentioned before, Elizabeth, many of our clients work for Amazon. We've done professional plans or national interest waiver endeavor plans for someone working for an employer which adds an additional layer of complexity, as you said, because we don't want the office reading this plan saying, oh, wait a minute, but the only that entity that benefits from your proposal endeavor is your employer. Or we've seen arguments like, okay, it's not really you, it's the 10,000 people working in this division, right? So we really need to focus always again in full coordination with the immigration lawyer and carving out the specifics of the endeavor and how it really makes a difference, and the benefits go and extend beyond the employer. So we do a lot of professional plans for these people doing research or independent consultants. So what's the best route? We have not seen a correlation between the type of plan and approval rates. I tell clients, look, an approval depends on many factors. And sadly, when you get an RFE or denial, what they didn't like or they're challenging. When you get an approval, they never tell you, okay, I like 70%, and this is what I like, and this is the thing that were kind of not so great, but I approved it anyway. So yeah, it depends, really.
And the standard is preponderance of the evidence, right? Somebody messaged yesterday, I want my case to be perfect. Nothing's perfect, right? It's the preponderance of the evidence, meaning it's more likely than not that you qualify.
Exactly. So if we were to use numbers, that would be 51%, right?
That's right.
Or 50.01%, right? Okay, but it seems that they're leaning towards the 99%, right? The USA, yes, like prove me everything, right?
Guilty beyond a reasonable doubt. No.
Exactly. Good stuff. Okay. When we write these plans, right? The main thing that we want to highlight is what exactly you're going to be doing and how and when. And as I always like to say, we don't write plans, we write children's books. It has to be so easy for a 10-year-old to get it. So the more complex the industry or the proposal endeavor, the more work that it takes to explain it in a way that it's easy to understand. And we see a lot of plans that clients bring, and they're trying to impress the officer with all this jargon and say, look, I think that you were denied because this officer didn't understand what you do. As simple as that. It is not your job to help you. I mean, you're responsible for explaining clearly to them what is it that you're going to be doing. Anyway, we'll address the what, the how, and the when, right? The well positioned. And as Elizabeth said, it's, very subjective, but we try to show in a nutshell that it's more than just an idea, right? I like to think that they're not approving national interest waivers because of people have a nice idea, right? Or even EB1As, right? Show me what steps you have taken or intend to take in the short term to make this a reality. So it's about the execution of, not just the nice idea. And we try to address, the interest, as the dinosaur language says, interest of potential customers, users, investors, and so on. And last but not least, the specific impact. Okay.
Marco, if I may, real quick.
Of course.
Progress toward achieving the endeavor, if you're going to be a consultant, can include things like articles of incorporation. I often encourage clients, even if they're not doing the EAD, which you can now with the bulletin being current, incorporate. It shows progress toward achieving your endeavor. Feasible plans for financial support, I think it's kind of a made-up criteria, but nonetheless, they're asking for it. What does that mean? How much? They don't say. So an employment contract is great. If you don't have one, or if you're still in school and you've got a lot of scholarships, I think that's useful. I also think it's useful to show bank statements or lists of assets to show feasible plans for financial support. Since the regulations don't have a dollar figure, they can't say it's not enough, but show them something.
Exactly. You're right. And by the way we address that is we analyze the industry, we do research, and basically ask a question, okay, a proposal endeavor like this, with this size and scope, in the real world, what type of initial investment would be required? So that when we're ready always to respond to an RFE with facts, because what we learned over the years is that when they challenge those numbers, they're not technical analysis. They're just saying, I don't like the numbers. And okay, what did you base your opinion on? We're basing our numbers on these verifiable sources. So what is your arguments, backed up by facts or sources or whatever. So we're always ready to respond to that RFE. Okay. Wonderful. Let's see. Let's see. It's 9 minutes to 1 o'clock, and let's see. We have several questions here. Let's see. Okay. I think this is for you, Elizabeth. I have clients on H-1B with pending I-140s. We're crazy to file AOS, of course, in order to get EAD for their spouses. Do you think this is a safer scenario because of the underlying status? Go ahead,
Well,
Elizabeth.
that's a great question. I imagine those clients are from India and the spouse is trying to get the work authorization. They've got the H-4. We touched on it at the beginning with premium processing and getting that I-140 approved. If it works for them and they've got the money and they are not risk averse, then I can see the value in doing that. But every case is different and everybody's individual considerations need to be taken into account. I'm not going to say blanket, yes, do it. If the person doesn't need the AD and or the budget is tight, maybe it's not the time for that.
Okay, thank you. Another question. What advice would you give an applicant with a pending I-140 for a national interest waiver from one of the countries under the proclamation? Nigeria in this case. Do you recommend a premium processing or should the applicant wait out till the re-review/hold is being done 90 days from the first week of January till we get another information regarding this?
Well, I would say maybe rewatch this webinar because I think we touched on that quite a bit, but know that it's probably going to be easier to get an exemption from the proclamation if you've already got that I-140 approved, because by approving the I-140, immigration is saying this person's work is in the national interest, which is one of the concerns about the proclamation. So strategically, it may be better to wait on the approval to file because they're not going to adjudicate the 485 anyway and request an exemption. But again, it's an individualized personal choice based on all of the things we just have been talking about in the last hour.
Okay, thank you. Another question for you. So you're the star today. I love it. So Richie, great presentation. Do you review NIW cover letters and provide instructions for improvements? And what are the modalities?
Yeah. So I carry malpractice insurance because I'm in several referral groups. Tallahassee Bar, for example, you're not allowed to do that. I'm not allowed, per my insurance, which I'm required to have, to review other people's work and give advice. And the reasoning by the policy is that if I've given you advice and I'm not your attorney and you relied on that advice, then I could be held accountable or responsible if it didn't go well. And I'm not controlling the entire case in this kind of proposal. People ask me that all the time. So I appreciate that. I do not do that. My insurance doesn't allow it. I'm sure there are attorneys who don't have malpractice insurance because they don't have to. You generally have to if you're a member of a referral service or who are willing to do it. But I am not one of those.
Interesting. I didn't know that.
Yeah.
Because the policy, okay.
Insurance, yep.
Wow, great to know. So this question is for visa-based suspense. Can the visa-based suspense help me define the proposed endeavor? Yes, but with a big asterisk. What do I mean by that? So it's many clients think that they're going to send us a resume and we're magicians and saying this is exactly what you have to do. So the way that we help is by thinking and analyzing and strategizing again with the immigration lawyer, right? Just looking at many different elements of that petition, because that when we write a plan, that plan has to fit perfectly that legal strategy. And so the attorney has to provide input on how to view the case, right? So we provide input on, again, looking at trends. What have we seen recently? What are the things that we have seen basically don't working, right? Or getting denied or challenged. So that is the type of service that we provide. I mean, it's not like we're here to say, okay, based on your background, this is what you should be doing. No, that's not how I think things should be done. Because even though, I mean, we're unlike lawyers, I mean, we cannot lose our, license or whatever, but it's the right thing to do, right? As simple as that. Question for you, Elizabeth. In case of a denial, is it better to refile or appeal?
Thank you for asking that question. So it depends, keeping in mind that appeals can take years. And let's just say a national interest waiver is denied on the basis of national importance, right? And then you file the appeal and you have this great national importance argument and the Administrative Appeals Office doesn't play by the rules of evidence like in criminal cases. They can come back and say, you know what? Yeah, you did meet national importance, but we're actually going to deny it for a different reason, which was not brought up in the denial. So they get to change the rules in the middle of the game. So I don't like it for that reason. Another thing to keep in mind is that if you're going to appeal, you cannot also refile with the same endeavor.
Hmm.
So it has to be a different endeavor if you're planning on pursuing both. Now, generally, I suggest refiling, but refiling doesn't get those decisions like in Mukherjee. The Mukherjee case demanded litigation because the person met all of the criteria, and it was immigration's contrivance, invention of the sustained claim requirement that was the basis for the lawsuit. And I'm thankful for that because now we can say, look, immigration, you can't require sustained claim anymore, which wouldn't have happened but for the appeal. So all things to consider. Timeline, do you have another status? By the way, appeal does not result in status while it's pending. So um I know we're running out of time, and I just realized there's a question about doesn't the proclamation apply only to consular cases, and I want to address that. An internal memo was leaked that says that it is applying to domestically filed cases.
Hmm. Okay. Perfect. Thank you. So what advice do you have for Nigerian students who are thinking of filing I-140s? We've worked. I'm not going to answer this, but I just wanted to share a fun fact. We've worked over the years with many Nigerian clients, and most of them have been from either Yoruba, Fulani, or Igbo. So it's we've learned a few things about Nigeria. Fascinating country. So go ahead, Elizabeth.
I
What
think
advice?
I would say rewatch this webinar. I think we've addressed that really well. Maybe we have room for another new question.
Okay. So I think you wanted to touch on this. Doesn't the proclamation apply only to consular cases?
Mhm. So that's where that internal memo says that it is not applying to consular cases. They are applying it to domestically filed cases. So there's a lot that goes on in immigration that we don't know. For example, had a case recently where something had to be filed, and the website for EOIR, now we're talking in the deportation realm, said X amount, and that's the fee that was paid. Internally, EOIR had notified staff that it was going to be a different fee. That was not made public. So people were paying the fee that was on the website, which dictates what the fee is, and people were
Mhm.
getting denied or rejected
Wow.
because they didn't pay the proper fee. So just because immigration says something doesn't mean that it's true, right? That especially now they are playing a lot of games and they are doing things internally and they're saying something completely differently externally. The proclamation is a great example.
Wow. That's crazy, but that's the game they're playing.
Mm.
So it's 1 o'clock already. We understand if you have to leave. Do you have a few more minutes, Elizabeth, so that we can answer some of these questions? So this is for Elizabeth. How many pages does a good national interest waiver plan have? So this is what we believe in, and this is what we've seen out there. There's basically two schools of thought, right? I've seen 50 to 60 to 70 page business plan that, in my view, and based on the fact that again they have 90 minutes, I can read 45 pages. Um, they're not going to read that. But not only that, look, if you're reading, I always say, if I am an officer, my job is from 9 to 5, read documents, and look, by 3 o'clock, man, I want to go home. I don't want to keep reading and reading. So the attention span, we have to think about that. So the two schools of thought are long business plans and short business plans. We strongly believe as a company in concise and short plans that address the key points and that include relevant information with no fluff. And honestly, 60, 70 page business plan, there's a lot of filler there. I mean, copy and paste. And then you have the officer trying to find the relevant facts. They're drowning in a sea of irrelevant stuff. It's a distraction. So the shorter the better. Usually our plans don't have more than 20 pages. Ideally, they should have 15. And I know that we're not talking today about e-visas and L-visas, but for e-visas, we do 3 page business plans when filings are in Madrid, 5 pages if the filings in Canada and France and Italy. And they're better. I mean, straight to the point, show me the facts, and so on. So that's my take on how long business plans are and should be. But again, if the lawyer wants a long one, we can make it happen, but I don't think that it works. So, question for you, going back to can I file to adjust from abroad?
Sure, you can file to adjust from abroad, but if you filled out your I-140 with that you were going to do so domestically, you're going to have to file an I-824, which is taking 13 and a half to 66 months to adjudicate to transfer the case. If the case were approved within the year, they're supposed to let you change to abroad without having to file an 824. But if you're from a proclamation country, you're not getting an interview.
Okay. Okay. Thank you. Let's see, from Nigerian students, how many pages can you, yeah, you were talking about that case, right? So go ahead.
The Mukherjee case?
Yeah, the
Yeah.
McCarthy case, yes.
So it came out late January. Was not my case, and basically it changed the standard to what the standard should be in EB1A, which is it does not have to be sustained a claim. That was an invention by immigration that is not in the requirements, and a lot of people had been being denied despite meeting the regulatory criteria. I've had several people, I mean, maybe half a dozen, who immigration said, yes, you met the regulatory criteria, but you didn't meet sustained claim, therefore we're denying you. They can't do that now. But Mukherjee was just for Mukherjee. However, I'm now giving a copy of it in my EB1A filings, and I'm making an analogy that if that were the standard for Mukherjee, that needs to be the standard for my next client, and you can't require sustained claim. You still need to meet the 3 out of 10 regulatory criteria. You still have to show you're going to benefit the country. You're at the top of your field, which, by the way, the policy manual says employment or research at an R1 or R2 or highly ranked foreign university counts as top of field, and that you're going to continue in your field. So it didn't entirely change the EB1A landscape, but it certainly is going to make immigration be more exacting in how they are approving the regulatory criteria, since now they can't rely on a made-up invented requirement of sustained claim. So it's a
Okay,
blessing and a curse.
perfect. Thank you. We have one last question. I don't think you spoke about 212F, right? Denial from consulates for those with
So,
approved I-140s,
so
right?
not denials per se, right? They're in purgatory.
Mm-hmm.
So if a
Okay.
case has already been approved and they went to the consulate and only because of the proclamation, they're not getting through. That's not a denial. That is purgatory, and that could last years, unless or until the proclamation is lifted, which could either be through litigation, which is happening, or the president decides to lift it. Now, if there's an actual denial, that's a different story, because as I mentioned, immigration now, they've got multiple billions of new dollars. They are going back and revoking I-140 approvals, saying they were issued in error. So if that's the reason, then you would have to do a refiling and request an exemption if you were subject to the proclamation and got an approval on that new 140.
Okay. Well, perfect. Well, thank you. It's 106. Thank you, Elizabeth, for sharing your wisdom and your insights. Really appreciate it. You have here the QR code to get in touch with Elizabeth if you have questions. And you can also reach out to us if if you need help with a plan, if you want a second opinion on, again, remember, not a legal opinion, but we review plans and we think how they can be improved to meet the current standards. So thank you again, Elizabeth. Really
Thank you,
appreciate it.
Marco.
Thank you. Have a nice rest of the day, and thank you to all the attendees.
Thank you for
Bye
being here.
bye.
Bye.